Hi, I'm Jeffrey Islander from Schlamm, Stone, and Dolan. Today I'm going to be talking about a very old doctrine of which many lawyers are unaware. It's the voluntary payment doctrine. A conundrum that lawyers often have in advising clients is where the client feels that there's a dispute as to whether the client owes any money. Should the client pay or not pay? I think many clients, even sophisticated ones, believe that if they pay a disputed amount, later on they can bring a lawsuit and try to get that money back. In fact, that is not true under New York law and hasn't been true for over 100 years. The voluntary payment doctrine holds that where a payment is made with full knowledge of the facts, the party making the payment essentially waives any right to recover that payment. For example, if you have a client who is dimly aware that perhaps the demand that's being made on the client is not lawful. Maybe there's a demand for a fee or a penalty that is prohibited by a statute or by some agency, and the client makes that payment. The court is going to hold that the payment was voluntarily made and the client can't recoup the payment. Another example is, suppose you have a client who's the co-owner of a business, and for some reason the client gets paid more in partnership proceeds than the client was entitled to. If the business entity making that payment, or the general partner making that payment, did so without full investigation, they are going to be out of luck. And I have to tell you from experience that the exceptions in the doctrine are very narrowly construed. So for example, when they say in the absence of mistake of fact or law, well, they mean in the absence of a mistake by both parties. Both parties have to really be under a misapprehension of what the law is or what a fact is for the voluntary payment doctrine to apply. The same restrictions as to a fraudulent statement on the payment doctrine apply as would generally apply to fraud. The other exception that courts have held, at least they mentioned sort of generically, is payment under duress. But duress defense has always been a very weak defense. It's almost never successfully asserted. So my advice is if you have a client who has any doubt as to whether a payment is legal or should be required, that client should either not pay at all or the payment should be made under protest with a full reservation of rights. Anything less and you're saying goodbye to that money.